What do you understand by writs? Explain the circumstances in which various writs can be issued. Or write a short note on I. Habeas corpus, 2. Mandamus, 3. Quo-Warranto, 4. Certiorari, and v. Prohibition. Ans. Meaning writs. According to Lord Halsbury, writ can be called those extraordinary remedies which are issued upon cause shown in cases where the ordinary legal remedies are inapplicable or inadequate. There are two kinds of writs: the prerogative writs and the original or judicial writs. The original or judicial writs commence between party and party, and they issue as of course. The prerogative writs are exceptional processes which issue only upon proper cause shown. As the prefix prerogative suggests, they do not originate from the enacted or common law but issue from the sovereign rights of the king as the fountainhead of justice. The prerogative writs are ancient remedial processes of an extraordinary nature, which have from the earliest time issued from the Court of King's Bench, in which the sovereign was always present in compensation of law. The jurisdiction to issue such writs was later on extended to the High Court of Justice under the Supreme Court of Judicature Act, 1925 in England. What writs can be issued? Under Articles 32 and 226, the Constitution of India confers upon the Supreme Court and the High Courts respectively the power to issue direction, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo-warranto and certiorari for the enforcement of the fundamental rights, and in the case of High Court, for any other purpose also. In the case of Fertilizer Corporation Kamgar Union v. Fertilizer Corporation, AIR 1981 SC 344, the importance of Article 32 has been explained in following words. The jurisdiction conferred on Supreme Court has been characterized as an important and integral part of the basic structure of the Constitution, as it is meaningless to confer fundamental rights without providing any effective machinery and remedy for their enforcement, if and when they are violated. I. Habeas corpus. This right lies when a person has been detained unlawfully. It may be used to secure release of a person from confinement without legal justification. In India, detention may be unlawful if, inter alia, it is not in accordance with law, or there is no valid law to warrant it, or the law is invalid because it infringes a fundamental right, or the legislature enacting it exceeds its limit. The great value of this writ is that it enables the immediate determination of the right of a person's freedom. In Kanu Sanyal v. District Magistrate, Darjeeling, AIR 1983 SC 653, the Supreme Court has held that while dealing with the application of writ of habeas corpus, production of the body of the person allegedly to be unlawfully detained was not essential. Justice Bhagwati held in this case that in a writ of habeas corpus under Article 32, the production of the body of the person detained is not necessary for hearing and disposing of the writ petition by the court. The production of body of the person detained illegally is not the essential feature of the writ of habeas corpus. Who can apply for the writ? The general rule is that an application can be made by a person who is illegally detained. But in certain cases, an application for habeas corpus can be made by any person on behalf of the petitioner, i.e. his friend or a relation. The writ of habeas corpus can not only be used for releasing a person illegally detained, but it will also be used for protecting him from inhuman treatment inside the jail. This writ is issued to the authority who has the aggrieved party in his custody. When on a petition for the writ the court considers that a prima facie case for granting the prayer has been made out, a rule nisi is called upon the custodian of the prisoner to show cause why the writ cannot be issued. If the cause is shown insufficient, the writ is issued for setting the prisoner free. The writ is not issued if the custodian can satisfy the court that the prisoner is not under unlawful detention. The Supreme Court has held in Janardhan v. State of Hyderabad, AIR 1951 SC-17 that if it should appear on the face of return that a person is in detention in execution of a sentence or an indictment on a criminal charge, that would be a sufficient answer to an application for a writ of habeas corpus. 2. Writ of mandamus. Mandamus is a judicial remedy which is in the form of an order from a superior court to any government, court, corporation, or public authority to do or to forbear from doing some specific act which that body is obliged under law to do or refrain from doing, as the case may be, and which is in the nature of a public duty and in certain cases of a statutory duty. No one can ask for a mandamus without a legal right. There must be a judicially enforceable as well as legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when he is denied a legal right by someone who has a legal duty to do something and obtains from doing it. In the words of the Supreme Court, there must be in the applicant a right to compel the performance of some duty caused on the opponent. The duty sought to be enforced must have three qualities. It must be a duty of a public nature. A duty will be of a public nature if it is created by the provisions of the Constitution or of a statute or some rule of common law. A duty corresponding to a private. 3. Quo-Warranto. By issuing the writ of Quo-Warranto, the court seeks from the person to whom it is issued information as to the warrant or authority by which the said person supports his right to an office, franchise or liberty. It lies against a person who claims or usurps an office, franchise or liberty with respect to which information is sought so that such person's right to the same may be determined in the light of the authority or warrant cited by such person in support thereof. The writ of Quo-Warranto cannot be issued unless the defendant is in actual possession of the office and exercises the office v. Green, 2 QB. 460. The holding of a liberty as a matter of fact is a condition precedent to the determination of a right to the same and the calling up of information with regard to it. A motion for a writ of Quo-Warranto can be made at the instance of a private person although he is not personally aggrieved or interested in the matter. The motion does not require the intervention of the government or any public authority. This type of writ is a discretionary remedy and is not issued as a matter. In G.D. Karkare v. T.L. Shevde, AIR 1950 NAD. 330, the appointment of the Advocate General of Madhya Pradesh was questioned by Quo-Warranto. An objection was taken that mere a private individual seeking neither enforcement of his fundamental right nor any other legal right cannot ask for Quo-Warranto. The High Court held that there was no reason to refuse a citizen under a democratic republican constitution to move for a writ of Quo-Warranto for testing the validity of high appointment under the Constitution. On merit, however, it was held that there was no defect in the appointment questioned in the writ. The writ of Quo-Warranto can go only to public offices and not to private bodies like the managing committee of a school, as has been held in Amrendra v. Narendra, AIR 1953 calories. 114. 4. Certiorari. it is a command or order by the superior court to an inferior court or tribunal to transmit a record or cause or matter pending before them to the superior court not to proceed with the case which is not within its jurisdiction, and also to quash any order made by the court in such a case. If the order of inferior court is found to be without jurisdiction or against the principles of natural justice, it will be quashed. In Champalal v. The Commissioner of Income Tax, AR 1970 SC 645, it was held that a petition for a writ of certiorari may lie to High Court where the order is on the face of it erroneous or raise question of jurisdiction of infringement of fundamental right of the petitioner. Who may apply? Any person whose legal right has been violated can apply for the issue of this writ. Any person may on behalf of a group of persons or society or persons at large. Grounds on which the writ is issued. The following conditions must be fulfilled before a writ of certiorari can be issued. 1. The act, order or judgment, in respect of which the writ is sought to be issued should be the act, order or judgment of an inferior court or statutory body exercising judicial or quasi-judicial functions. 2. Such court or body must have acted in absence or in excess of the jurisdiction vested in it the principles of natural justice so as to render such act, order or judgment invalid. 3. Where there is violation of the principles of natural justice so as to render such act, order or judgment invalid. 4. When there is an error apparent on the face of record. In the case of Gujarat Steel Tubes v. Its Mazdoor Sabha, AIR 1980 SC 1896, Supreme Court explained the meaning of the phrase error apparent on the face of record. It was held that every order cannot be corrected merely because it is wrong. It can be quashed only if it is vitiated by the fundamental flaw of gross miscarriage of justice, absence of legal evidence, perverse misreading of facts, serious errors of law on the face of order, jurisdictional failure and the like. In Harbanslal v. Jagmohan Saran, AIR 1986, 302, it has been held that the writ of certiorari is issued only if the order of the inferior tribunal or subordinate court suffers from the error of jurisdiction or from breach of principles of natural justice or if vitiated by an apparent error of law. The grounds mentioned above for quashing the orders are self-explanatory of the term error on the face of record. Prohibition. A writ of prohibition commands the court or tribunal to whom it is issued to refrain from doing something which it is about to do. So writ of prohibition is issued by a court of superior jurisdiction directing an inferior court for the purpose of preventing the inferior court from usurping a jurisdiction with which it is not legally vested or to compel courts entrusted with judicial duties to keep within the limits of their jurisdiction. Thus the writ lies both for excess of jurisdiction and absence of jurisdiction. Prohibition has much in common with certiorari. Thus both these writs lie against a judicial or quasi-judicial body but not against an executive body. But there is one fundamental distinction between the two writs. They are issued at different stages of the proceedings. When an inferior court takes up for hearing a matter over which it has no jurisdiction, the person against whom the proceedings are taken can move the superior court for a writ of prohibition, and on that, an order will issue forbidding the inferior court from continuing the proceedings. On the other hand, if the court hears that case or matter and gives a decision, the party aggrieved will have to move the superior court for a writ of certiorari, and on that, an order will be made quashing the decision on the ground of want of jurisdiction. Sometimes the two writs may overlap. Thus it may happen that in a proceeding before the inferior court a decision might have been passed which does not completely dispose of the matter, in which case it might be necessary to apply both for certiorari and prohibition, certiorari for quashing what has had been decided, and prohibition for arresting the further continuance of the proceeding. Broadly speaking, a writ of prohibition will lie when the proceedings are to any extent pending, and writ of certiorari for quashing other they have terminated in a final decision. It is well settled that where proceedings of an inferior court or tribunal are party within and party without jurisdiction, the prohibition will lie against doing what is in excess of jurisdiction. In Bengal Immunity Company Limited v. State of Bihar, AIR 1955 SC 661, Supreme Court observed that the existence of an alternative remedy may be more relevant in the context of a writ of a certiorari, but where an inferior tribunal is shown to have usurped jurisdiction which does not belong to it, that consideration is irrelevant and the writ of prohibition has to be issued as of right.